Contract performance and breach regards whether a party has performed all, or at least enough, of its contractual obligations, such that it merits the benefits of the bargain. Whether a party has sufficiently performed or materially breached is the key issue in whether that party merits the benefits of the bargain to which they were promised. A party who has materially breached their agreement is not entitled to the benefits of the bargain, whereas a party that substantially performed is entitled to the benefits. Therefore, we have to distinguish between substantial performance and material breach. Most contracts contemplate an exchange of promises. For example, if you mow my lawn, I'll pay you $20. In these exchange of promises, the obligations of one party only come due when the other party has sufficiently performed its obligations. Under this exchange of promises, it's implicitly understood that I don't have to pay you $20 until you mow the lawn. And what if the lawn is mowed really badly? Do I still have to pay you 20 bucks? How good a job do you have to do in order to get paid? The legal answer to the question is, it depends. Surprise. But what does it depend on? It depends on whether you substantially performed or whether you materially breached. So if you did a terrible job mowing the lawn, you shouldn't get paid. Whereas if you did a good enough job, you should. How do we distinguish the difference between them? There are actually 4 forms of performance and breach which need to be distinguished. The first and happiest is complete performance. That is the full performance of an obligation as detailed precisely in the contract. 100%. Not everything is done 100%. In fact, sometimes 100% performance is basically impossible. The doctrine of substantial performance says that when a party performs the primary, necessary, material terms of an agreement, the other party has an obligation to perform its obligations, which frequently are paying for the benefits of the bargain. However, performance that is not substantial may be in material breach. A material breach is where there is a defective performance, such that the performance does not materially fulfill the obligations of the contract. And finally, there is total breach. In total breach, the party has failed to perform its obligations and can never perform its obligations. This chart summarizes the effect of the different forms of performance and breach as a legal matter. The first legal issue is whether the other party, the non-breaching party, the party to whom the obligation was due, must perform its mutual obligation. In the example of mowing the lawn, yeah, you had to mow my lawn, and then I had to pay you. So, do I have to pay you? The answer is yes, so long as the performance was at least substantial. Complete performance, absolutely, the other party has an obligation. But I also have to pay if the lawn was substantially mowed. Whereas, if the performance was insubstantial, we are in a state of material breach, and I am allowed to withhold my performance. However, I cannot cancel my performance until we have entered total breach. The distinction between material breach and total breach is that the non-breaching party may only cancel when the cure period has expired, when the breach has become so substantial that it is total, such that it can never be performed. Otherwise, if we're in material breach, while I don't have to perform yet, my obligations to pay may later come due. Let's deal with liability for a minute. To be clear, any breach, and substantial performance is a breach, it's not complete. A breach is any performance that is not perfect. Whatever is not perfect about it is breach, and any breach can result in liability for damages. So a party who substantially performs, yes, they are to be given the benefits of the bargain that were promised. In the lawn mowing example, you got to pay them 20 bucks. However, the obligee, the person who was to receive the lawn mowing in this case and didn't get a perfect job could technically sue for any difference between what was promised and what was given. So we have to divorce in our minds the concept of whether or not the other party must perform for whether a party is off the hook and no longer liable for damages. Because in a condition of substantial performance, the non-breaching party has to perform, but can still sue the breaching party for damages. The first analytical step is recognizing where there has been some breach, and this is usually pretty easy. Distinguishing performance and breach is easy because any failure to perform any contractual promise, when that promise is due, is a breach, and any non-performance is usually easy to recognize because the contract will promise one thing and a party did another. Now, this of course requires some level of contract interpretation, but once we understand what the contract required, we can usually see pretty clearly whether or not it was completely performed or not. Anything that is not complete performance is a breach and can give rise to liability for damages. The effect of a breach is that the breaching party is liable for damages. But unless the breach was material, the injured party is not permitted to withhold performance. The injured party may withhold performance if the breach was material, but cannot withhold performance if performance was substantial. In other words, if you've performed substantially, then you are owed the benefits of the bargain that were promised to you in the exchange of promises. It matters a great deal whether we have substantially performed or materially breached. In fact, this is usually the hardest part of the performance versus breach analysis, because the line between substantial performance and material breach is actually kind of fuzzy. As a result, we look to the 5-factor test in Restatement Section 241 as a guideline for determining whether or not there has been a material breach. Before I get there, I apologize in advance for using some funny names in this next section, but just to define them, I'm going to talk about the obligee and the obligor. The obligee is the person to whom an obligation is owed. The obligee is owed an obligation by the obligor. Until that obligee receives the promise, the obligation, the obligee may withhold its own performance under an exchange of promises. The obligor is the name for the person who owes the current obligation, which is at issue. And this is the person whose performance is being judged. I use these funny terms, obligee and obligor, because they more accurately represent the situation, which is that both parties have obligations to each other. What we're focusing on in doing this analysis is whether the party whose current obligation may or may not have risen to the level of substantial performance or complete performance, that's the party who's being judged. That's who we're looking at. Once that party performs, then the other party, their obligation becomes due as well. And so they actually switch roles between obligee and obligor as performance occurs. I hope that helped. Let's get into it. Pause here to read the black letter rule from the Restatement Second of Contracts. Section 241 distinguishes substantial performance from material breach, and I've simplified the restatement's analysis with this visual chart here. This illustration shows that we are working with a balancing test. Whether we're going to find there was substantial performance or material breach has to do with a balance between 5 factors. I think there's you can think of them as 6 factors here, and I'll explain. The biggest factors are going to be whether the obligee, the person who was to receive some benefit of the bargain, got what they were promised. If the obligee did not get what they were promised, they were deprived. The extent of this deprivation is the first factor. If there was a significant deprivation, we are more likely to find material breach than if there was only a small deprivation. We balance that against the obligor's forfeiture. If the obligee is not required to perform its obligation, the obligor will be deprived. So if you mowed the lawn badly and I didn't pay you at all, you were deprived $20. The extent of the obligor's forfeiture will weigh against the counsel for material breach. If the obligor is to forfeit quite a great deal, we might find substantial performance occurred. Moving back to the obligee's side of the ledger. If the obligee has valuable remedies at law, then if we put the obligee in a situation of substantial performance, that obligee can sue for damages. Those are the most common remedy at law would be money damages. If there are good remedies at law, we might feel more comfortable declaring substantial performance and allowing the obligee to sue at law. On the other hand, if there's not a good way to win a lawsuit, we're going to be more hesitant to find substantial performance and rather declare material breach so that we create a situation where the obligor has to actually fulfill its benefit of the bargain. And that leads us to our fourth factor, whether the obligor is likely to fulfill its benefit of the bargain, also known as cure. If the obligor is likely to cure, seems ready and willing to fix the problem, we should feel more comfortable declaring this material breach and putting the obligor in a situation where it has to make that cure in order to receive its benefit of the bargain. Fifth, and not least, is good faith and fair dealing. The restatement frames this as whether the obligor acted in good faith, but I've actually seen cases where the courts consider and compare the relative good faith and fair dealing of both parties. So I think that given that this is a quasi-equitable doctrine, the degree to which both parties acted in good faith and fair dealing has a great deal of impact on which party should win the case. What if we find a material breach? What is its effect? Well, the breaching party will be liable for any injury caused by the breach. Of course, anytime there's a breach, the breaching party is liable for damages. But what's new here, what's different about this situation is now the injured party, the obligee in our example, can withhold performance. The injured party can withhold performance for a reasonable time, also known as the cure period, which leads us to the idea that there is a right to cure a material breach. A party in material breach has the right to cure the breach by substantially performing within a reasonable time. And cure means fixing the defective performance as to make it a substantial performance. If cure occurs during the cure period, now the obligee has an obligation of their own to perform its mutual promises. Failure to cure the breach, however, by the obligor, if the obligor never actually fixes the problem, after some amount of time, we will declare the contract is cancelable, and the non-breaching party can find someone else to do the work as we fall into a state of total breach. How do we distinguish then between partial breach and total breach? Some guidance comes from Restatement 2nd of Contracts, Section 242. Pause here to read the black letter rule from the Restatement 2nd of Contracts. The Restatement 2nd of Contracts, Section 242 has an additional set of factors that distinguish material breach from total breach. The first is the degree of the material breach, which we would calculate using the 5 factors set forth in Restatement Section 241, shown on the left side of the screen. In addition, we have 2 new factors. And what is common about these 2 new factors? The factors are whether delay hinders the obligee from making reasonable, suitable, alternative arrangements, and whether the agreement provides that time is of the essence. Time and delay. The new factors added have to do with time. In other words, the cure period. We distinguish material breach from total breach by evaluating whether allowing a cure period would cause additional harm. The effect of total breach is, just like always, the breaching party is liable for any damages caused by the breach. But now, here's what's new. The injured party, the obligee, the non-breaching party, may cancel the contract and is no longer obligated to perform ever, can be excused from its obligations. So total breach declares that the cure period has ended, which means, as a matter of law, that the obligee, the person to whom performance was due, the non-breaching party, has the right to cancel the contract and get somebody else to do the work. Let's conclude. Complete performance is a happy state of affairs, where the party has done everything it promised. It's like a pole vaulter who goes completely over the pole vault. It's beyond dispute that performance was excellent and that party is due the benefits of the bargain to which they were promised. You did everything that was asked of you, and now it's your turn to receive your benefits. There is no further liability in this situation, and therefore the parties are happy. They got what they wanted, and there will be no lawsuit. Substantial performance, on the other hand, is like finishing a marathon, but not exactly coming in first. Yes, you did the work such that you qualified, you get your participation medal, or in the case of someone who's working for a fee, you deserve to get paid for that work. But this is not as happy as complete performance because you can still be sued for any difference between what was expected of you and what was actually given by you. Material breach occurs where a party has not performed its obligations such that the obligee received its material benefit of the bargain. This is like a hurdler who fell down during a race. The hurdler has two choices: get back up again and finish the race decently, or just quit. In material breach, likewise, the other party has to wait and see. Is the breaching party going to fix the breach? Because during material breach, there is a cure period. There is a time during which the other party can still perform and make good on its obligations. However, this doesn't always occur, and sometimes the situation degrades from material breach into total breach. But during this cure period, the non-breaching party simply has to wait and see if the breaching party is going to fix its defective performance and make it substantial. At some point, however, it is no longer required to wait. At some point, it is obvious that the breaching party is never going to perform, or it's too harmful to the non-breaching party to wait any longer. And now we can abort, cancel, terminate, extinguish the contract. Total breach is the state of affairs where it is no longer reasonable or legally permissible for the other party to perform and for the other party to wait for that performance, and so we allow cancellation of the contract at this stage. In conclusion, we have 4 states of contract performance and breach. The happiest is complete performance, which discharges any liabilities by the performing party who has now done everything that was promised, so there's no liability under law, and creates obligations in the obligee. Now the obligee becomes an obligor and has to perform its promises, which are often to pay. Substantial performance means you still get paid for the work that was done. The obligee now becomes an obligor. But there is still liability for breach, so it's not quite as happy as a circumstance because there could be some outstanding liability. But the remedy is not self-help. The remedy is not withholding performance, but rather performing and then suing for the difference between what was given and what was expected. Material breach is one state worse. In material breach, the obligee has not received the material benefits of the bargain. But we must allow a little more time for this to be fixed. This is called a cure period. Once the cure period has expired, however, we are in a state called total breach. In total breach, the obligee, the person who was to receive the benefits of the bargain and has not received them, may cancel the contract and find someone else to do the work. And we would find it more easy to determine a total breach where the non-breaching party is harmed by waiting. And for that reason, we give the non-breaching party the right to cancel and find someone else to do the work.